One important law in California that both the bicyclists and the drivers of cars should be aware of is the so-called 3-foot safety distance rule. So, California Vehicle Code section 21760C defines the 3-foot safety distance rule as follows. A driver of the motor vehicle shall not overtake or pass a bicycle proceeding in the same direction on a highway at a distance of less than 3 feet between any part of the motor vehicle and any part of the bicycle or its operator. The law specifies the minimum safe distance, but sometimes more than 3 feet is required to ensure a safe pass. It is the driver's obligation to ensure and maintain the amount of safe distance required under any particular scenario encountered by the driver. So, what is the significance of this law? Well, if you are a driver of a car, then you simply need to know that if there is a bicycle in front of you, you should be further than 3 feet away from that bicycle when you're trying to go around, because it is your obligation to be away from the bicyclists. And if you're not, and you clip the bicyclist, or somehow the bicycle leans a little bit in your direction while you were less than 3 feet away from that bicycle, you might be found fully or partially responsible for any collision between you and the bicyclist. Even if it's not your fault, the fact that at the time of some type of incident where there was a collision, or maybe the bicyclist fell, even without a collision, because maybe the wind or the air from your car pushed them and made them fall, whatever else might have happened, the fact that you were closer than 3 feet to the bicyclist at the time of that incident might make you partially liable for that incident and for that bicyclist's injury. Now, if you're a bicyclist who have been involved in an accident because you were hit by a car, of course, it's very important to try to find out whether the distance between the car that was passing you and your bicycle was less than 3 feet, because that will make the driver liable or even more liable. And what do I mean by more liable? Let's say the driver hit you because they weren't paying attention or they were texting, so they're already responsible for hitting the bicyclist. But in addition to that, they were trying to pass you less than 3 feet away from you, which makes their negligence even more significant and more egregious. Now, of course, the challenge is proving how far away from the bicyclist the driver was passing. There's different ways of proving it. One could be your own testimony as a bicyclist. You could say, look, I was riding my bicycle and I saw how the car was coming on my left, and it was definitely closer to me than 3 feet. If the car tried to brake quickly and there are tire marks on the road, that might be evidence of the distance between the car and the bicycle. There could be witnesses, there could be pedestrians, there could be other drivers who saw how the car was passing you and they were very, very close to you, and definitely closer than 3 feet away from you. But that law is very important to be aware of, again, for the drivers of cars to stay away and to minimize their chances of being liable for this type of incident. And for the bicyclists, it's a tool to enhance their potential injury case by showing that the driver, again, was negligent or even more negligent than he otherwise would. And this could potentially translate into a greater settlement and greater compensation for the injuries suffered by the bicyclist. Thank you.